According to the First Amendment, Congress shall make no law abridging the freedom of speech. Does this mean that Congress shall really make no law limiting freedom of speech? No. Court decisions have accepted that some restrictions may be placed on this fundamental freedom, while at the same time, in the last 2+ centuries, the court has expanded the definition of what kinds of speech are protected. Not long after the ratification of the Bill of Rights, the First Amendment was subject to a fundamental challenge. The country's politics devolved into bitter partisanship between two emerging political parties, the Federalists and the Republicans, or Jeffersonians, a group which eventually became the Democratic Party that exists today. A Federalist-controlled Congress passed the Alien and Sedition Acts in 1798, which, among other things, made illegal any false or scandalous and malicious writing against the government. While criticism of the government seems precisely the kind of speech the First Amendment was meant to protect, the law was used to convict more than a dozen Jeffersonians who had harshly criticized Federalist President John Adams and the Congress. In the 1800 election, Republican Thomas Jefferson defeated Adams and became president. In his first inaugural speech, Jefferson argued in favor of the right of all to think freely and to speak and to write what they think, and reject political intolerance. More recently, in 1969, the court established a test to determine whether or not speech was protected by the First Amendment. Clarence Brandenburg, a leader of the Ku Klux Klan in Ohio, appealed his conviction for breaking an Ohio law that prohibited speech that urged violence or terrorism as a means of political reform. In Brandenburg versus Ohio, the Supreme Court held that speech could be restricted or punished only if it supported imminent lawless action. An example of such speech might be someone urging a crowd to take up weapons immediately and storm a government building. Not only are spoken words protected, the court has also protected symbolic actions as a form of protected speech. In 1969, in Tinker versus Des Moines, the Supreme Court held that symbolic speech, or expressive behavior that employs gestures or actions rather than words, was protected, ruling in favor of students who had been sent home from school for refusing to remove black armbands that protested U.S. policy in Vietnam. Likewise, in 1989, the Supreme Court upheld the constitutionality of burning the American flag. In Texas versus Johnson, it was argued that if there's a bedrock principle underlying the First Amendment, it is that the government may not prohibit the expression of an idea simply because society finds the idea itself offensive or disagreeable. The courts have also determined that campaign spending is a legitimate expression of free speech. In Citizens United versus the Federal Elections Commission in 2010, the Supreme Court declared unconstitutional the part of a campaign law that limited the amount corporations and labor unions could spend to promote the election of particular candidates for federal office, because it violated the right to free speech under the First Amendment. It is important to remember, however, that some types of speech are unprotected by the First Amendment, including libel, slander, obscenity, child pornography, and hate speech.